And my guests are seated. We will get straight away into introducing my guest to you, and then we'll look at the loaded issues, very deep issues that we have to look at this morning. And my guest are Abdul Malik Kubako, editor-in-chief of the New Crusading Guide. He happens to have also, is it edited or written a foreword to this very powerful book I'll show you in a brief while, In Pursuit of Jubilee. And Mr. Bako has some truths in the foreword that I'll share with you shortly. So that's it. Then Yao Pong is a lawyer and teaches the law at the Central University. Also, James Ogalga is MP. He's a lawyer and MP, Bolsa North, a former Deputy Minister for the Interior and ranking member, Defense and Interior Committee of Parliament. Also, that's to my extreme left, is Alexander Kwamena Afenyo Marking. And you notice that I took my time pause because last week I did say something else instead of Kwamena Afenyo Marking. He's also a lawyer, MP, a FUTU, and member, Public Accounts, Defense and Interior Committee of Parliament. Gentlemen, good morning and welcome to Newsfile.
Good morning.
Great. Okay, what a morning is going to be, a morning full of attention on the Supreme Court and also on the NDC and the report by Professor Kwesi Boche. A report by Professor Kwesi Boche. Then we'll look at various other issues. The Supreme Court has given 3 very important judgments that we are going to look at today. And we'll look at them in substance and in some various other ways. Now, we are privileged to be the first to share with you certified copies of the orders of the courts, and we shall be bringing you some bit of detail of some of the judgments that you may have read about and heard some erroneous interpretations of as well, and claims that may not have been borne out by what the court had to say. So we begin with the matter I say appears to be a matter of coincidence, as the Supreme Court asserts Ghana's sovereignty and says President Mahama's administration was wrong and wrong Ghanaians and the U.S. Allowing them to dump the 2 GITMO detainees on Ghana. The U.S. is also very busy at the same time deporting Ghanaians allegedly under very, very inhumane situations, but the U.S. Embassy denies that. And also something that people are feeling very hurt about, that the embassy is requiring certain persons, class of persons, high up in the society, including President Kufuor, President Rawlings, President John Mahama, to queue up at its embassy to get visas for their personal trips to the US of A. Right, so we'll start with that. And in respect of that, let's get to hear a bit of what has brought us to that topic for discussion this morning.
Going forward, there will be clear guidelines as to how we conduct the affairs of the state, which is the distinction between a democracy and a military rule. And that is exactly what has happened today. I'm very happy. I mean, the Americas, the United Kingdoms, and other advanced democracies, we all see and appreciate. The things they do that we appreciate, they never happened overnight. It took decisions like these. For instance, the decisions of Mabry versus Madison, and so many decisions that made America what it is. And so I'm very happy. I think that we are going places, and I'm so grateful to God that democracy that was embraced in 1992 is being advanced in various ways through individual efforts, aside what is being done at the level of government by parties such as Nana Boakye and Mrs. Margaret Bamfo. And so I'm extremely grateful. You're also playing your part. It's also beautiful. We should continue, through such actions in court, to correct errors on the part of state actors, for the advancement of our democracy and its entrenchment.
To respect the ruling of the Supreme Court that those diplomatic letters and exchanges ought to be treated and should have been treated as a formal treaty agreement and therefore requires parliamentary ratification. Let it come as I listen with the full facts and the justification, but like I said, there is more to it as part of our commitment to fight terrorism and relationship with the U.S. in global strategic efforts to fight terrorism must have informed the government decision at the time. Probably what the Supreme Court have said, that the government erred. The government erred to the extent that it was construed as a diplomatic letter exchange and not a formal treaty agreement. But now that the Supreme Court has made a pronouncement, we will all now be guided in our future dealings to subject all those processes to parliamentary consideration. We have not met as a minority, and our position will be based that we need a strategic diplomatic relationship with the U.S. to fight terrorism. Our decision will be based that we took this decision mindful that it was just exchange of diplomatic letters, but now construed properly and lawfully by the Supreme Court as a treaty which ought to be approved by Parliament, and then we'll take a decision based on the national interest.
There's no monetary consideration, and the U.S. itself would have disclosed if there was any monetary consideration. And so what you're seeing in social media that I collected 300 million to accept these detainees is absolutely untrue. The detainees question was a direct request from the United States of America to my government. We have been allies with the United States for a very long time. It didn't start today. We have partnered in a lot of things, and we continue to collaborate in areas of security, in areas of training with our armed forces, in areas of defense. And so when we received a request like this, we said we will appraise it, and based on the appraisal, we will take a decision. Extensive consultation was held both internally and externally. A risk assessment was done by the U.S. itself, and these two detainees, Al-Dubi and Benatef, were considered to be the most compliant detainees in Guantanamo camp, and they were put in the lowest risk category in Guantanamo. And let me be clear, people say ex-convicts. They were never tried, they were never charged, they were never convicted. And America itself did assessment and gave us their risk category. It was the lowest risk category. It was also established that they had played no operational role in Afghanistan. Our own national security visited the camp several times and conducted extensive assessments and interviews of these detainees. As Commander-in-Chief of the Ghana Armed Forces, the safety and security of this country is of the greatest concern to me, probably than any Ghanaian. I will not take any decision that would jeopardize the safety and security of this country, because it's my duty to ensure that this country is safe. And so we took this decision after a lot of assessment and consultation. And the point about terrorism is what you should fear is what you don't know, not what you know. Indeed, any Ghanaian is more in danger of dying from, say, a road accident than from these Guantanamo detainees, because they are with our security services, they are monitored 24/7, they are under surveillance. From their own interviews that we've done, they just want to pick up the pieces of their lives and live normally. And so we don't have anything to fear from them. In any case, the alliance that we have assists us because we are members of ECOWAS. We've adopted a visa-free entry into each other's countries. And so it means that anybody in the ECOWAS region can come into Ghana without requiring a visa. And so if we say even Boko Haram is being fought in Nigeria, it means any person who probably is associated with it can just take a car and travel into our country without requiring a visa. And so in a circumstance like that, what you need is advanced information about who are coming into your country, who.
Right, so you heard a lawyer for Mrs. Margaret Bamful and Henry Nana Boakye, who were the ones who took up the matter in the Supreme Court. That is Nana J. Bafo Ewa, who is the lawyer for the two. And then you heard Haruna Idrisu, who is the minority leader in Parliament. And finally, you heard President John Dramani Mahama. Also, you remember when how he explained the justification, the humanitarian grounds, among others, for which Ghana admitted these into the country. Now, in the end, the Supreme Court made this order. And I'm reading from the certified order of the Supreme Court. It was a matter that was heard by 7 of the justices of the Supreme Court, and you had 6 of them unanimous agreeing, and 1, the Justice William Atuguba, dissenting. And I can't wait to read that dissent. They said that the court holds that by a true and proper interpretation of Article 75 of the Constitution of Ghana, the President of Ghana, by agreeing to the transfer of Mohammed Mahmoud Omar Mohammed bin Atef and Khalid Mohammed Salih Al-Dobe to the Republic of Ghana, required ratification by an act of parliament or a resolution of parliament supported by the votes of more than 1/2 of all the members of parliament, and by virtue of the failure to obtain such ratification, the agreement is unconstitutional. Consequently, it is hereby ordered that unless the government of Ghana, within 3 months from the dates hereof, that is Thursday, submits the agreement to Parliament for ratification and obtains the same, as in obtains ratification, the said Mahmoud Omar Mohammed bin Atef and Khalid Mohammed Salih Al-Dobe shall be returned to the government of the United States of America. This is rather serious, isn't it, James?
Well, Samson, good morning to your viewers. Well, our position right from day one was that the decision to admit the 2 ex-Guantanamo Bay detainees into our country did not fall within the remit of Article 75, and that when the President acted, he did so under Article 73 of the Constitution, because that particular provision entitles the President to conduct our diplomatic relations in a manner consistent with our national interest. But the Supreme Court has spoken, and so we are all bound by the verdict of the Supreme Court. But some say the fact that we are bound by the verdict of the Supreme Court does not mean that we cannot disagree with the verdict. Unfortunately for me, as a lawyer, I haven't had the privilege of reading the judgment. And so as I sit here, I don't know what informed the decision, the conclusions arrived at by the majority, the 6 members of the panel ruled, in favor
a
of
substantial part of
the
what the court said, as far as your position is concerned, which as late as June, the Attorney General also filed further, arguments to among others, suggest that that decision was good. That there is some distinction between the agreements that ought to go to Parliament and certain agreements that are a bit informal and presidents can engage in and to bind the nation. Because in the United States, a similar thing happens. In fact, they went to the South African Constitution, which also allows some of that. But the courts ended up and said, our Constitution bears no distinction between executive and non-executive agreements. So that argument falls flat on its face. In fact, it said, it also appears that under the agreement, Ghana is obliged to integrate the two persons into Ghanaian society. I guess we didn't know about this, but they have read portions of the agreement, which is not in more formalized agreement, but some notes that clearly bind Ghana. And the note actually says, the court says, the note inter alia, Ghana binds herself to, quote, receive and, quote, resettle the said two persons and assure that for at least 2 years, we were told that just 2 years, but the agreement appears to have an opening for more than 2 years, for at least 2 years or longer if warranted by circumstances. And these are quotations from the agreement, which was said to be national security matter, so cannot be made public. And the court said, no, bring it to the court. These persons are kept under such conditions, monitored and surveilled, as would accord with the security assurance in this agreement to be implemented. And this is where I was going to read to tell you that the court tells you why your argument is flawed. It says, it also appears that under the agreement, Ghana is obliged to integrate the two persons into Ghanaian society. This is a unique obligation since it compels the virtual migration of the two persons into Ghana. If the arguments of the defendants, that is the state, were to be taken seriously, i.e., that the transaction being by way of a note verbal, executive agreement, memorandum, or understanding, diplomatic note, or what have you, is merely an administrative one, then the question arises as to the exact status of the said persons now that they are in Ghana. Are they migrants? Should the application of our sovereign laws on immigration be compelled by another state? Are they refugees? Their situation does not fall into the definition of refugee under Article 1 of the UN 1951 Convention on the Status of Refugees, as amended by the 1967 Protocol thereto, or Article 1 of the 1969 AU Convention governing specific aspects of refugee problems in Africa. There is therefore no doubt that the arrangement, unique as it is, cannot be made without parliamentary ratification. This is sufficient for you to proceed.
Well, yes, Samson, yeah, I think that I have the gist of the Supreme Court's reasoning. But like I said, we still hold the view, of course, we respect the verdict of the Supreme Court, that to subject the conduct of the executive's diplomatic relations, every single step, to parliamentary ratification would make the exercise of the president's power, executive authority, to conduct our diplomatic relations very cumbersome and laborious. Look, it is a time-honored practice for the executive, for presidents, to engage their counterparts bilaterally. And when they do, sometimes the very nature of the engagements or the arrangements that are struck have certain implications. Sometimes they are so sensitive. As we speak now, a number of arrangements are in place which benefits us. I mean, it's to our national interest.
Such as?
We're able to receive, I don't want to talk about some of them because of the sensitive nature, but it's a common practice. States generally share intelligence on security-related issues. I'm not saying we do because I cannot divulge some of the things, which inures to the benefit of countries. You see, in the international arena, now, if you require that, per the Supreme Court's verdict, all such arrangements must be brought before Parliament for ratification, I am saying that the hands of the executive is going to be tied unnecessarily. They would not be able to act in a timeous manner and in consistence with the provisions in Article 73. The ruling has been made, but I'm saying that if we apply this particular ruling strictly, a number of engagements that are in place which have inured to our benefit and continue to inure to our benefit as a country would have to be brought before Parliament for ratification. When that is done, the secrecy which ought to come with national security interests is going to be broken to the detriment of our country and all countries that are engaged in that form of international diplomacy in one way or the other. So yes, we accept the decision of the Supreme Court. It is binding on all of us. But I am saying that to some extent, it could be injurious to some other interests, national interests of countries that engage in these things. But Samson, having said that,
we are hearing from some of you, the minority in Parliament, suggest that, well, this was the desire of the opposition then, now the government. So they said, we didn't want these people in our soil. So now you have the opportunity, take them back.
Well, I think that the verdict of the Supreme Court is very clear. What it means is that the admission of the two into our country, I mean, needed to have come before Parliament for ratification. And so, as it stands now, the government has two options: to either bring up the said agreement, that which we didn't consider as an agreement under Article 75, before Parliament for ratification. Parliament is not bound to ratify agreements brought before it by the executive.
The court is clearly aware of that, and
yes.
that is why it says failure of getting that approval.
Parliament may
they should go.
Refuse to ratify the agreement. In the event that Parliament refuses to ratify the agreement, the government will be left with no option than to send back the two ex-detainees to where they came from.
The government of the now minority brought these guys into the country. So you can do nothing but to ratify. The government in opposition then, which had issues, also may want to protect certain interests, and so will not act contrary.
Well, they have a comfortable majority in Parliament, so if their decision is that they will stand by previous convictions of theirs, and from the very top, they all held the view at that time that we brought into this country terrorists who could endanger our national security, even when they knew that the two in question had been held unlawfully for 14 years without the preference of a single charge of terrorism against them.
At the time, it is safe to say that with the exception of the NDC and its members, perhaps not all of them, the entire nation was against it.
Well, Samson, if you say the entire nation was against
everywhere,
it,
they were issuing statements left, right, center.
I mean, well, that is why I'm saying that they may have been misled because because they were described as terrorists. And that we were reckless, we brought into our country terrorists when they knew that the two had never been convicted for any terrorism charge. In any case, it is gratifying.
If America doesn't want some people, then certainly there must be reason for that.
No, they cited security reasons. I mean, for instance, the very security of the two individuals could not be guaranteed in the United States because of the perception that these two may have been complicit in the 9/11 attacks. So the considerations were varied. But Samson, the point I'm seeking to make is that when you read the statement the Minister for Information has now issued, the fact that the two are well behaved, they have comported themselves, what is he driving at? Is he now, beating a retreat? And to say that the two, after all, are capable of going through some reformation?
In fact,
if that is the case,
one of them got married whilst here in Ghana.
Very well. If that is the case, what would the clergy, some sections of the clergy, which say no, they have sinned, let them be hanged, and that I see forgiveness. I mean, it's totally alien to the Holy Book, the Bible. What would they now say in the face of the statement made by the Minister for Information?
The NDC minority is expecting the agreement in Parliament, and it will, without any hesitation, ratify same.
No, we are not saying that. I mean, when the agreement comes before
Parliament, ratify it.
Parliament will take a decision. I can't sit here and say that Parliament will ratify it. No, Parliament is an independent organ of state. When agreements come, I can sit here and preempt anything.
But what you were defending, you should not have hesitating to say that you are going to ratify.
We took a certain position that we would stand by. We still stand by our views that they were not terrorists and that they deserved
Now let's hear Alex. Now let's hear Alex. And you know, when he was referring, and you hear the NDC continue to make the argument that this is state practice, time-honored state practice, that presidents hold bilateral, discussions. They agree on things. Not all of it should be open to Parliament for ratification. This argument was actually made by the Attorney General in the court. And the court, when he made the example, when he said there are other arrangements we have benefits from, when I asked him for an example, I wanted him to mention one thing, because that's the only thing they mentioned. They mentioned military training sessions and cooperation agreements.
Sharing of intelligence.
Agreements on joint military training sessions and memoranda of understanding in support of certain international courses. The court said, well, what are you talking about really here? And in any case, you haven't shown us any of those to compare. But this is what the court said, most importantly, to reject that argument. It said, state practice, quote unquote, state practice, unfortunately, the references made in support of such distinction relate not to Ghana's constitution or state practices developed therefrom, but rather to practices in the United States of America, where there appears to be a long-standing practice to distinguish between, quote, executive agreements, unquote, which are signed by their president without the approval of Congress, and treaties that require such approval. The defendant, that's the Attorney General of the state in this matter, also made reference to the Republic of South Africa, where such distinction is specifically provided for in their constitution. The court said, this is America, this is South Africa. Our constitution says a different thing. We'll keep to our constitution.
Well, Samson, since the days of Magna Carta, common law principles have evolved. The rule of law principles have also evolved, and our courts have had the exclusive mandate of interpreting the law and bringing into question decisions of other organs of government. It does not come as a surprise that once again, when the court was called upon to give effect to the law and the constitution, the court rose up to the occasion. The NDC's argument that they came under Article 73 is not tenable. I see it as more political than legal, because my learned senior seated by me here knows all too well that when you are reading a law, you don't read sections thereof and leave others. If you do so, then you're looking for convenience, and that will not be helpful. The whole Article 73, 74, and 75 have to do with international relations. So the 73 that they are talking about is just giving you the power. And even so, if I may quote, government of Ghana shall conduct its international affairs in consonance with the accepted principles of public international law and diplomacy in a manner consistent with the national interest of Ghana. The MPP made an argument of national interest. Have you made sufficient consultation? Have you engaged all stakeholders, including Parliament and its subcommittees? He and I have served on the Defense and Interior Committee. We were not even aware. In fact, when the matter became public, he himself, on public radio, had said that then the Interior Minister was not even aware. His boss. If I'm misquoting,
we're told that the Interior Minister then may have lost his job because he said this.
Well, it is not. Sorry. Let me withdraw that quote from you. The Interior Minister appeared not to be aware, not him. I remember your interview, so I don't want controversy here. You are my good friend. The Interior Minister himself appeared not to be aware, and he said so publicly. Now let's talk about the legal issue. You must read 73 together with 75. Where those powers given you have been qualified. And here is the provision. The president may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. Treaties, agreements, or conventions. What you have said is that you exchange note verbal. What form did it take? An agreement? Yes. If so, why not Parliament? In any event, why is it that the executive often sees Parliament as a stranger to governance? When it comes to issues of national security, you mean your Parliament cannot be part of it? You should conduct certain business of national security in nature on the blind side of Parliament? Then you don't need Parliament.
But do you realize one thing though? You know, in the United States of America, when Donald Trump took over and decided to begin on a certain journey, and the Attorney General acting did not believe in it, the honorable thing she did was to just check out of the system.
You know.
Now we have an Attorney General that has gone to court, and I'm talking about the present Attorney General, has gone to court to defend a position that the ex-administration stood by. And here we have the party in government saying something different.
You see, Samson, I think that we should deal more with the principles, the various rules assigned to certain organs of government, rather than trivialize it, an individual going there and the present Attorney General, what she did or did not do. What is the issue? The issue is that government of Ghana, whether past or present, has taken a view that a matter of this nature ought not to come to Parliament.
Okay.
A Ghanaian citizen has challenged it in accordance with Article 2.
Two Ghanaian citizens.
Well, two Ghanaians, very well, have challenged the same. The court says that no, this should have come to Parliament. And that we are giving you options. Either you go to do ratification in 3 months from today, or send them back.
I'm saying that in principle, now, would it not have been expected that the Attorney General would just not go and put up any argument and say, we also believe that Article 75 ought to have been applied and wasn't applied, so we can't argue. But the Attorney General went and said, state practices, US presidents do it, South African presidents do it, so Ghana can also do it. And here you are, the party is speaking, and the government, so to speak, somehow is speaking differently.
Let me get the architecture right. So what you're trying to say is that, well, the MPP in opposition had a view. Now, your expectation is that the learned Attorney General should have acted consistent with the then position.
The NPP spokespersons now, official spokesperson of government now, still say that the NPP's position in opposition is what they stand by. Meanwhile, what they stand by is contrary to what the Attorney General argued in court as recent as June 16 or so.
There's no contradiction, and I explain to you why. Publicly, we had argued that the then government needed to engage in a broader consultation. Publicly, we had argued that even Parliament did not know the details of the said agreement. In fact, government officials had even said publicly that they did not know.
Right.
Now, if soon thereafter certain facts come to your knowledge and you have certain legal opinion on same, nothing binds you to your previous opinion, because obviously if you now up to certain facts, you're able to say, okay, this is what it is, and you are trying to relate it to some other practices. Nothing stops you as a lawyer to argue a case.
Okay.
That one, nothing stops you. I mean, you are making a legal argument. But, of course, there's a blend of legal and political arguments. All right? And if you want the political story to be told, then we go on to say that, look, yes, you had looked at it with a political eye. Nobody would want a tagged terrorist to be in his territory. You are putting your own nation in harm's way. Obviously, and a country where the media determines the order of the day. If you are not careful and the media is making noise that, hey, you brought in terrorists, and you know that you did not consult, you did not engage the very people that you serve, what do you expect them to say? I mean, if I'm an opposition leader and suddenly I get to know that there are some ex-Guantanamo detainees in my country and there was no such level of consultation, and even the parliament of the republic was not engaged at all, and it comes to my notice again that even members of cabinet claim they were never aware. The interior minister, who is part of the national security apparatus, says that I was not aware. Then obviously there's some mischief, there's some bad faith somewhere, and I have every right to question. It wouldn't be wrong to question that. No, please, no, take notes.
I want to correct.
No, you don't need to correct anything. Please, I'm not quoting you again. Stop it. Just take notes, James. If your own cabinet, some members of cabinet come out to say that, oh, we were not even aware. What do you expect an opposition leader to say? In any event, today, the law and the position as espoused has been confirmed that you needed to engage Parliament. You needed to bring it for ratification. We didn't say bring it for us to approve before, because the position is that, yes, it's an international agreement. Note verbal, you've exchanged, there's an agreement. So soon thereafter, bring it. So I do not see anything wrong.
So the majority is expecting that cabinet will bring this note, memorandum, whatever, diplomatic note or whatever they called it, whatever the Attorney General describes it, that it will be brought, cabinet will deal with it, bring it to Parliament, and you, as a majority, will ratify it.
Has it come? It hasn't come.
Is that the expectation?
No, it hasn't come. I'm not in leadership, but I am a member. I'm sure that when it comes, because it's security in nature, maybe Mr. Speaker could direct that there should be a joint committee, the Foreign Affairs and Defense and Interior. I don't know, but it's most likely.
Okay.
When it should come.
Okay.
We would have to let me finish
before you go to.
No,
James, I want to pass on information. It's important.
But I think your point is made. You can't make a decision for the majority.
Well, yes, sure.
Right.
I mean, when
quickly,
it
in
comes
30 seconds.
I just need to state that Parliament was briefed as a committee of the whole by the
after the fact.
By the Minister for Foreign Affairs.
Right.
I mean, it was a closed sitting. Arguments were taken. I think he was in the chamber, and so
no.
But we need to put that on record. We need to put that
after the Broha.
We need to put that on record.
No, we talking after the Broha. Which record?
No.
And obviously, what he's referring to
we were talking about issues before.
Was done with all what has been tagged as the arrogance of power at the time. Look, we've done it, so what? Shut up. You know. I don't know, but. Am I overflogging this? That the court, as recent as May, asked them to bring certain, submissions. And the Attorney General goes and says, this is not supposed to go to Parliament. it was done the way the US president can do, the way the South Africa president can also do. Let it be what it is, a diplomatic note. In fact, they argued, contrary to the earlier fear-mongering, so to speak, that the fears that we're talking about, security threats that we're talking about, were sort of a figment of our own imaginations. And so there's no fear, there's nothing to worry about. And this is the Attorney General.
That's right.
Should the government and its functionaries and the now party in power be heard to speak differently?
Well, that's an interesting question. Thank you very much. But I think on the contrary, it shows that the Attorney General is conducting the cases and her functions as a professional.
Right.
Maybe in the past we haven't had such familiar conduct in terms of some Attorney Generals. But I mean, the fact that we recognize that the Attorney General's position, though may be personalized, it is an institution. And as you can see, yesterday, on Thursday, the Attorney General herself was not in court. One of the chief state attorneys represented the Attorney General. And they maintained the position.
Of course, so we ought to note that the whole argument for the state began with Dominic Ayine,
yes,
right?
Yes. So I think that it is also part of the evolution of the pact that, or the principle that we have adopted, rule of law and constitutionalism. The fact that one government has left power, who appointed a different Attorney General, and there's a new one, doesn't mean that as a lawyer, you are just going to conduct your cases based on political convenience. Because when you leave power, you go back to the bar, you ask yourself certain questions. Was it your duty to apply the law or apply what the politician deemed convenient for their own purposes, whether re-entrenchment or whatever? So I think that it is once again, it is one of the successes that we have chalked in terms of the administration of justice and even by politicians. So
I'm asking because the Attorney General is not only the principal legal advisor for the government, according to Article 88, but also takes instructions from the President.
Yes, I mean, 88, of course, the Attorney General shall be Minister of State and principal legal advisor to the government. But when it comes to institution of civil actions, for example, it is solely for the Attorney General. So sometimes I'm worried when I even hear some presidents say that I have instructed the Attorney General to do A, B, or C. Of course, the Attorney General, the clients of the Attorney General is not the president, it's the people of Ghana.
No, but the law says the president can assign the Attorney General work to do.
Oh, yes,
right.
Obviously. I mean,
that means you take instructions from the president.
No, but that is why I'm saying that the Attorney General is a professional. The same thing as you. Somebody comes to you, he narrates his case to you. This is my case, take it to court. If you believe, and we have that duty as lawyers, not to go to court based on those set of facts, not only because the person will not win, but because you will not be able to discharge your fundamental duty to be truthful.
But is this decision sound to you? Do you agree with the 6 judges?
Oh, yes, I do. But I must also say that I also enjoyed, I had the privilege of being in the court and enjoyed the decision of Justice Atuguba as well. And as we say, we are all looking forward because it's important to get other angles. And also shows that we must, at the same time, entertain dissenting opinion. Because that is how we build law. That's
what is the thrust of Justice Atuguba's dissent? That will be saddling the president with too much to go to Parliament and discuss?
Well, honestly, I don't think I heard that part, even though I heard him read fully. Under serious circumstances that he described, not under the weather and so on, but his boldness, as he will put it in reference to others, his characteristic boldness and excellence in delivery was not dwindled by the fact that he was under the weather. I mean, I enjoyed him read. But the main point is that according to him, this matter related to the issue of aliens. And that when it comes to aliens, international law prevails. And he cited, I think, Captain and the Salabi cases. I've forgotten, but I think Captain and quite a number of them. And incidentally, a decision that Nana Akufo-Addo's own father gave to support his opinion that, look, this is not new. matters like this have happened in the past, and the Supreme Court, Kufuado, JSC, this is what they said, and his whole judgment or opinion was substantially.
What did he say?
Well, he said that when it comes to the issue of aliens, the absolute power, as it were, is vested in the executive to arrange their receipt and maybe their return to where they came from, so to speak. It was in reference to the aliens compliance.
Would that reference to the people's MPs in Parliament?
I think the difference may be that now our constitution may have changed the situation, because when you look at this whole issue that we are referring to, Article 73, in fact Article 40, 41, in dealings with other nations, the government of Ghana, of course, shall promote and protect the interests, plural, of Ghana.
Right.
Then also, Article 73, the government of Ghana shall conduct its international affairs in consonance with the accepted principles of public international law and diplomacy.
Did you say 41?
40. 40A. Forgive me, 40A. Now, the government of Ghana shall conduct its international affairs in consonance with the accepted principles of public international law and diplomacy in a manner consistent with the national interests of Ghana. Now, these provisions came up for interpretation in what I will call simply as the Argentina vessel case. All right, the fully entitled.
We remember that. It's okay.
Yes. Now, in that case, Datiban said that neither of these constitutional principles, that is the 40A and 73, is to be interpreted as altering the dualist stance of Ghanaian law. They do not authorize the court to enforce treaty provisions that change rights and obligations in the municipal law of Ghana without legislative backing. If the law were otherwise, it would give the executive an opportunity to bypass Parliament in changing the rights and obligations of citizens and residents of Ghana.
What's the meaning of the dualist stance? Because it brings this issue in focus.
Okay, well, I mean, it also brings to focus Article 75.
When you say a country is a dualist country instead of a monist country, what does that mean?
What it means, as I understand it, is that the executive may enter into treaties and international agreements, but they cannot be enforceable or effective unless either, depending on what it is. For me, if it's an agreement, Parliament will have to ratify it. If it's a treaty or convention, then Parliament will have to approve.
Okay. In fact, the plaintiffs said that as a dualist state, Ghana's consent to be bound by an international agreement is only deemed to have been properly secured after the same has been approved or ratified by Parliament. This is a clear statement of the law, really.
Yes, that's
okay. Right. So quickly, and then I'll go to.
Yeah, so,
but the requirement to give legal effect to treaties, agreements, and conventions are so provided under 72A and B. 70. So 75, yeah. A and B.
Right. Okay.
So I mean, just suppose that your views on that clearly on these two properly, because you are saying that when it comes to agreement, it should
in honesty, we can argue about it,
but my job is to try to avoid you guys, even though these are technical matters, to get you to avoid being too technical and as it were legalistic about it. But the references they are making is that Article 75 says that the president may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. And then it goes ahead to say a treaty, agreement, or convention executed by or under the authority of the president shall be subject to ratification by A, Act of Parliament, or B, a resolution of Parliament supported by the votes of more than one half of all the members of Parliament. And that was the argument of the plaintiffs.
And I'm saying that when it comes to agreement, it is by resolution. An act of Parliament brings into being a law.
Right.
And an agreement, when ratified, doesn't even become law.
Please, can you move on?
So
Just
my point,
move on. Yeah.
no, but let me also make reference to the Parliament. Please, can you show me any agreement that is law?
Don't go to that debate again.
There are procedures for making law.
Don't go to that debate again. Okay,
let me move on.
Please.
My point is that
it becomes valid.
You see, the Supreme Court now has continuously emphasize, and by referring to Lord Denning, it says the truth is that the law is often uncertain, and it is continually being changed, or perhaps I should say developed by the judges. In theory, judges do not make law, they only expound it. But as no one knows what the law is until judges expound it, it follows that they make law. The point is that without the concept or the principle of judicial review, executive in particular, and maybe by extension the other organs of state, will feel so powerful, overly powerful that...
And judicial review means that the power of the court to review, as it were, challenge the acts of all other entities of state.
And make them understand that their powers are limited by the law that establishes them. And for me, I think that is the very key point.
Should they ratify this?
Well, first of all, I haven't even seen the agreement. I don't know whether any member of parliament has
you are unlikely to see it.
I'm unlikely.
But the effect of it is that we received and we agreed to settle them for 2 years or more.
I think that this should even be a blue chip for us. I mean, elsewhere, other countries would have held on to this particular position. And somebody joked about it. Maybe one GITMO guy to stay here, 1,000 Ghanaians to stay in America. I mean, you can make humor about it, but it is an important tool because it can hugely embarrass
so we'll
America.
We'll be dovetailing this part to that argument. So they are hoping to deport, is it 7,000 Ghanaians who are in America. And so far, how many have been brought in now? And your opponent is suggesting that why not? We keep one GITMO detainee, and then, you know, you also agree.
10,000.
Right. Yes. Kokoro has been writing in red and underlining a lot of archives. So, what do you say? You love the decision by the courts?
Fantastic. And let me begin by congratulating the plaintiffs, Nana Boachi and Madam
Margaret Bamford.
She's about 80-something. Yeah, fantastic. It's this element of civil society activism and advocacy that I think would help consolidate our democracy.
That was my take this morning.
Yeah. Fantastic. Occupy Ghana, Citizen Movement Ghana, all those groups, you know, it's a new generation. It isn't as if we haven't had some before. We've had political activism that brought about this democratic dispensation that we're having. But within the context of some 24, 25 years of Fourth Republican democracy, this emergent tendency, phenomenon, is positive for us, and it helps the courts to get activated and to do the right thing.
Maybe we will soon also have to call Afenyo Marking Ghana, because he's also on that that tangent, it's going after a lot of state institutions and asking the court to annul stuff that they have done.
It's a right spirit and must be enhanced and promoted. So my congratulations to the two citizens who decided not to be spectators. Yes, and they began this thing somewhere January, is it? Last year.
Yes,
if I recall. But you've said something which I was completely unaware of, and I would really want to read whatever the Attorney General, and I mean the incumbent Attorney General, presented to the court. I really would love to cite it and peruse it. Because
beyond my reading it, you mean? Okay, go ahead.
I find it a bit intriguing. Let me be honest with you. And I'm happy the court didn't listen to that submission. But it brings up a lot of conflicting signals. There may be another paradoxical element in there that could help the administration eventually when it comes to the propagandist debate our friends in the NDC are waging about. You said take them out. So once the court has given you two options, choose the option of take them out. It may, in a very paradoxical way, help them. But I'm intrigued by that stance, which, as you indicated, also conflicts the official party position then and even now, in terms of the sound bites.
Which may have become government position.
Yes. So it's very tricky. And I would love to interrogate that thing further and find out why. Because you see, if I recall, Professor Michael Quay, who's incidentally now the Speaker of Parliament, after the President Mahama held his press conference, for the first time to elaborate on why government had taken the decision. And President Mahama made a point that this was not something that ought to have gone. He said it was neither a treaty nor an agreement for which he should have gone to Parliament for approval. This was President Mahama's view. Professor Michael Kwe came out and said something, and I would want to quote. He said,
go ahead.
"The president is woefully wrong. An agreement is an agreement, whether verbal, telephonic, sealed, or whatever. Without an agreement, those persons could not have been here. Whatever the understanding between the U.S. and Ghana, there was some offer. There was some acceptance, and an agreement was reached between the two nations and duly executed. If the Attorney General advised the president to the contrary, then she must apologize to Ghana and resign. This is elementary law."
In court, they describe it as note verbal, and they describe it as diplomatic note. They refuse to refer to it as an agreement.
Yeah, but Professor Kwe also, in a way, said whether verbal, telephonic, sealed, or whatever.
Yes, the court actually went to a UN convention and read it to show that it captures it as an agreement, no matter how loose it appears.
Yes, so the point remains. And so I'm surprised that in sharp contrast, this Attorney General representing the party, the ruling party, which in opposition had insisted that what had been done had no legal constitutional basis because it required parliamentary approval. There was a second segment of the argument, which was the security risks assessment matter, which I think we'll get a chance to deal with as well. But in terms of the substantive, it was the lack of parliamentary ratification. That was the substantive argument. In fact, on some occasions, references were even made to the Terrorism Act
That is
and
so.
the relevant portions.
That was also brought up in court.
Interesting. So I find it very difficult, but let me put that aside, except I think there's something not right for me relative to
professionals.
Well, you may call it so, but well, you are the lawyers. I'm just talking from the street point of view. But I'm intrigued by it, even though I say paradoxically it could end up helping their case when it comes to the propaganda arguments. You know, the supremacy of the Constitution has been upheld.
Yeah.
For me, that's really good. The independence of Parliament, the authority of the legislature is also been upheld in the sense that take it back there, get Parliament to rectify. Then, of course, I think the judiciary too is working. Yeah. Very activist judiciary. In the last week, we had about 3 or 4, and I couldn't believe what was happening. But that shows that we are doing some good things to ourselves. And then, of course, the pronouncement on the...
I'm just looking at what the Attorney General filed.
Please do.
I just wanted to refer to something for your benefit.
Sure.
And this was filed on the 24th of May.
This year?
Yes, this year. And the Attorney General says that the plaintiff's contention is that the presence of the 2 detainees poses a threat to the security of Ghana, and therefore government should not have agreed with the government of the United States of America to accept the 2 Guantanamo detainees into Ghana. The plaintiff has, however, not been able to adduce any evidence to suggest that the president did not take the security of the country into account in agreeing to admit the 2 former detainees into Ghana. It does appear that the president, by a certain act, does not act by himself. Thus, the entire National Security Council, established by the Constitution and assigned the functions in Article 84 to ensure the security of Ghana, has not suggested by any means whatsoever that the security of the country has been endangered by this action. It is our humble submission, and this is what I was referring to, that the plaintiff is unnecessarily worried, has no basis to worry, and has not established any reason why this court or the people of Ghana must be worried about the security of the country.
Yes, but the substantive issue for me was the constitutionality or otherwise.
The security was also important.
No, I'm coming. As a substantive.
The statement issued by the NPP. We may visit
no, you are not getting.
Yeah.
That's why I said we'll deal with that subsequent. But you are not getting my drift. My drift is that in this whole saga, the constitutionality or otherwise was primary. And indeed, the judgment itself makes that case. That's where the judgment is rooted in. The unconstitutionality of the agreement is where the key is.
Right.
The security is there, it's important, and I will come to it. But you see what it means? So it means that the Attorney General, where you've quoted, I haven't heard her talking of the constitutionality or otherwise. Maybe she addressed that too.
Yes, she does, but this is also a question that needed to be addressed.
Yeah, then maybe I was a bit too excessive in my critique of her, because if the security thing was not the primary thing she was pushing, to ask the court perhaps to endorse the agreement on its own. Because I got the impression I got based on your submission earlier was to the effect that, look, the Attorney General had gone there and said there's absolutely nothing wrong with this agreement. It was properly done.
Exactly, you are right about that.
In all fairness,
that's the sum of the Attorney General's submission.
Order that the court made for the parties to file supplementary statement.
I agree.
Correct.
So this is just to support an earlier one where they have argued that there was no problem with
but there's a problem.
ratification.
See, yes. So if the Attorney General, indeed, by what you've just quoted, because I was going to be a bit charitable now, that she might not have been looking at the constitutionality or otherwise, as in this particular paragraph you read. She was looking at the other segment, just like we are also going to segment.
I read about 4 paragraphs though.
But we are segmenting.
Right.
That's what we are doing here. So if it's the security side, I'm telling you, I share the same position based on even earlier things we said on this platform. Okay. Last year, I mean, and then subsequently this year, I share that position that the security threat has reduced, if there was any, considerably. You see, don't forget the conditions under which this whole security matter came up. Then people have to answer for themselves. Anybody, the Catholic Bishops' Conference, the Christian Council of Ghana, they raised the security as the key.
Right.
Whilst Isankoma, Jogate, and others raised the constitutionality, if you recall. But Rolate came out, and it's similar to what this...
But the NPP was in the lead on the security and whipping people.
They raised both legal, the NPP raised legal, constitutional, and security. It's true. They did. And I have it here, it's on record. They raised all that.
Just to help but it's important, what you read. You see, this is what I see on the document file 24th of May. It's a legal submissions on the relevance of Article 83 and 84 to articles.
I don't want us to get too technical, but bottom line.
Not technical.
Bottom line. I said this is May. This is what the Attorney General filed, correct?
Let me finish. Let me finish something.
We have spent quite a bit of time.
I know, but let me finish. It's important. It's important for the argument.
Oh, but he just said it. Like the court asked them to bring additional argument, and they brought it. I think it may not be of moment.
No, it is important.
Okay.
Because from the angle Kweku is moving, I beg you. Legal submissions on the relevance of Articles 83 and 84 to Article 75 on treaties and the question of estoppel in international law upon an executed treaty filed pursuant to order of the court dated 10th of May.
Correct.
So, clearly, the court wanted the Attorney General to make additional submissions anchored on these 2 provisions of the Constitution.
That's right.
Juxtapose the requirement and the 83 and 84. Reconcile them with 75.
Okay.
So I just want you to, I want the viewing and the listening public to get this as additional understanding as to how the
Attorney General came by the purpose for which the reference was made remains substantive. That this is what the Attorney General thinks about the security of the presence of the people here.
Yes, but not the constitutionality of the agreement. That's the layman view, uneducated understanding.
I want you to quickly finish up, and then we'll add the diplomatic, spat, so to call, in it, and then we see, because he's suggesting we should use this as a weapon.
No, I don't see the basis for that. I'm sure he was just joking.
Oh no, I wasn't.
No, come on. How? Those Ghanaians out there. What's their legal status, their immigration status? Those Ghanaians who are being brought back home, What's their immigration status?
Illegal.
Thank you. We may we may have problems with how they are being handled, processed, and being brought home. Maybe let's take a look at that and insist, because these are fundamental human rights that have universal character. That we can focus on and demand that the right things are done. But if you are somewhere out there and you are not by law out there according to the country's law, why should I go and use you as a bargaining chip? It's such a serious matter. No, please. I'm sure my brother is.
And while that is happening, you are being told that your ex-presidents must queue up there and for their personal visas, for their personal travels.
Don't let's mix all those things. The immigrants, the illegal immigrants out there, they are not in the same category like ex-presidents. So we can draw.
We're just putting them together.
When you put everything together, as I say, you create a forest so much that the diseased trees get lost. We can't find them.
Once you get to the forest, you can
but obviously, it's so undignified. If you're talking of the ex-presidents, I hope they don't mean it. Maybe we need further and better particulars.
He was very
They
clear,
were talking about if it's private, personal, tourist visits.
You have to come there.
You have to come there. Our ex-presidents.
Yes.
Personally, physically. Yes. No, they are wrong. They have protocol officers. How many ex-presidents do we have in this country?
Says the protocol officers will only handle official travels.
No, they can exempt the ex-presidents, the former presidents, from that category. They have, look, we have even, they establish foundations, they deal with international community, different organizations, even if it's a private visit, which could sometimes be medical related and all those things. How many ex-presidents? What's the workload? We have only 3, or?
Yes.
We have 3. And I'm sure they are not going anytime soon, obviously. But what is the workload?
But should it not be extended beyond ex-presidents, ex-vice presidents, and other
but when I say presidents, when I say president, I add vice presidents. Right. To be honest with you, that's the mindset. You might even add speakers.
Exactly.
Yeah, so we can discuss that about the category.
You are saying they are wrong. The ambassador was very clear and emphatic. He emphasized it, that if you are doing an official travel, the protocol officers will handle it. But if it is a personal, private travel, your ex-presidents even must queue up.
I disagree. I think they can fine-tune it. They can bring in some little bit more finesse and dignity. But I don't want to mix the two. They're two separate, distinctive issues. Dealing with GITMO 2 and the Supreme Court judgment.
So you are dealing with it quickly because we are going for a break and come to deal with another important issue. So what do you...
aspects, that's concluded.
Which one is
that? So if you
which one is that?
This thing about, it comes with the security.
Okay.
That we should take them back because some people said that they pose a security threat. And our friends in the NDC are leading that campaign. I've heard 2 or 3 members of parliament saying they will
led by Clement Appa.
Yes, pathetic. It's really pathetic. It's petty politics. In any case, when the matters were going on, they told us, this is Felix Kwachu, and he spoke to Joy. He says according to him, there is no way the two can leave the country per the agreement signed regarding their stay in the country. The ex-detainees were not brought here against their will and cannot leave before the 2 years agreement signed between the government of the US and the government of Ghana. So all we can do is, as a country, to put measures in place to prevent the peace of this country from being undermined. Their stand, and I have more, the president himself said so, is that we cannot return those people. At that time, it was an illegality. Now the Supreme Court has given us the option to rectify. When we rectify, they are here, per the agreement. And it's not even 2 years up. And apparently, I didn't also know that the 2 years was the minimum.
I didn't know.
I didn't know. Now I know. And I'm told one of them has married. Professor Prempe says an unconstitutional marriage.
An unconstitutional marriage. We also ratified that.
So please, let's be honest and consistent. Look.
Wait, you speak briefly and then we'll move on because we have done 1 hour of discussing on this.
I am surprised that those who...
Very important issues are emerging.
I am surprised that those who committed an act of unconstitutionality are not feeling embarrassed but are rather trying to divert attention to what some people said relative to security and insist that let the people go.
Interesting.
It's pathetic.
You finish up. I'll go this way.
But you see, another fundamental matter.
2 minutes about the diplomatic thing, about the request that ex-president and stuff must come to the embassy.
Yes, I mean, as I said I was applying humor. But with all seriousness, it's a very important potent tool. For example, with this, can't we use this to negotiate?
No.
With even the former president, I think you find to be an embarrassment.
This is so much risk we have taken.
It is a very important tool that we can apply. And the Americans do it all the time. I mean, diplomatic circles.
Right.
These things are used all the time to change decisions of states.
That agreement is locked up, it's closed.
Okay.
Well, in any case,
you may have got your own benefits already.
The 2 years.
Don't forget that.
Okay. Professor is making a key point. And what you are suggesting will be a renegotiation.
Yes, which is not right. It cannot be done.
In any case, the part of the agreement you read says that 2 years, which will elapse end of August this year, or as may be extended if necessary.
Right.
So
we are not bound.
Then we have an opportunity to renegotiate with them. If they want them to stay here, these are our expectations on the table. We use that as there
are greater benefits. There are greater benefits.
The understanding really is that upon the expiration of the 2 years, we are taking them back to America. Is that what it is?
Well, that's another question. Where do you take them to? Not to America, because they didn't come from there. Not to Guantanamo.
When Amma is married.
I want to react to Kweku's submission.
But whilst you react to this, we are looking at the diplomatic stuff. And Dr. Vladimir Nchidanso is saying that what is happening should not be taken lightly. That the deportations happen at a time when we have summoned the ambassador to parliament, and he says your ex-president have to queue up at their place.
I'll come to that. Kweku just made some submission which seem to suggest that we in the NDC should be ashamed because of our unconstitutional act. But Samson, if there is any group which owes the Ghanaian people an apology, it is the MPP. You know, starting from Nana Kumia, he said, under President Kufuor, the ex-detainees would never have been admitted into this country.
Just hypothetical
The now Minister for Information, Honorable Mustafa Hamid, said that Ghana risked being attacked for admitting the ex-detainees.
Are you sure you are quoting?
No, he said something like that. It's true. He said something to that effect. It's a fact.
Then the Minister for Communication, Esle Kufu, told President Mahama to apply the laws and return them to where they came from.
That's a fact.
The president himself, that Mustafa Hamid added this, and I quote him: Nanado thinks the process is flawed, and was wrong for government to accept them.
Fact.
So
the process is flawed.
Yes. Very well. Whichever way, whether the process
not whichever way. That is
whether
very
the
key.
process was flawed.
That is very key, and that is what the court.
So that is what was a security
the level of security threat. Yes, something I'll do that. I mean,
do that in a minute.
Yes. So for me, the point I'm making is that the MPP has not been consistent. If they bring up this agreement for ratification, I'll be surprised because then they will owe the people of Ghana an apology.
Okay. So
that is if they
elect to bring
up the agreement before Parliament for ratification.
But you, the court has ruled
what's talking about this?
Fiat. Those who have predicted that we're likely to have a diplomatic row with the United States if we were to send back the ex-detainees may be right in their prediction. But for me, the point is, our Supreme Court has ruled. The Supreme Court has said the act of admitting the detainees was unconstitutional. The United States Embassy in Accra has stated that they respect the decisions of our judiciary and these processes. So we are waiting on the executive to take a decision. But I have said that given the stance the MPP took when they were in opposition, it should be very interesting.
Please, can you abandon that and let's move on? Should any ex-president go to the U.S. Embassy? I'll move on without you. Should any ex-president go to the U.S. Embassy for visa?
It's absolutely wrong. It's marks of disrespect to our statehood, our nationhood.
What should the government do? What should the government do?
I think that we should protest.
Okay.
Outright protestation.
Thank you. Yes, Alex, yes.
And use this.
You are going to have to go and queue there and get your visa.
Well, the official position of government is that effort will be made to engage the embassy or the United States rep in Ghana for a review of the said decision. So let's see.
People feel insulted by it. Do you feel the same?
Well, obviously, I mean, even when the man appeared before the Committee of Parliament, I don't think that a Ghanaian ambassador can put up that posture before the Senate Intelligence Committee or Foreign Affairs Committee of the Senate. But once again, you know, when somebody is flexing his muscles, it tells you where he derives his power from. But it shouldn't be. You are on our soil, and there should be that respect.
Reciprocal.
Okay? It should be very mutual. You must not be seen to be undermining.
But some feel that they are justified, though, because look, who are we? We abuse every opportunity.
But the ex-presidents abuse.
But
do they have such
evidence? By the way,
evidence?
Samson, we are forgetting something. We shouldn't be surprised, and I say so because when John Benjamin wrote his letter, he said he was going to circulate it to other diplomatic missions in Ghana. He said so.
Yes, but did it include ex-presidents and vice
what
presidents?
I'm saying is that he did not.
They are being too extreme.
Yes, I'm saying that that is their interpretation, and that is where I think that all of us should draw the attention that you can't go to that extent.
Okay.
Yeah.
Well,
you can deal with individual cases, but you
there
cannot.
are some people who say, well, you may not be proud of Zimbabwe, but if he had made this comment in Zimbabwe, he would have joined the next flight back to the United States of America. We'll be right back to deal with other matters as far as the Supreme Court is involved. And, you know, they've handed down such hefty stuff in one day or in 1 week. And then we'll find out whether the peace building or peacemaking tour of the NDC ordered by the Kwesi committee will bring the NDC back to power in 2020. We'll be right back.